Justice and Correctional Services Minister Michael Masuta has welcomed the Constitutional Court's decision dismissing the DA's application to have direct access in a bid to challenge government's withdrawal from the Rome Statute of the International Criminal Court.
The court found that the matter did not invoke the jurisdiction of the Constitutional Court and that it was not in the best interests of justice for the court to hear the matter at this stage. The news comes on the eve of the meeting of state parties. Minister Masuta will be travelling to The Hague to address the meeting of the Assembly of State Parties.
Now, earlier we spoke to our correspondent Sherwin Bryce-Peace regarding the impending address by South Africa to the ICC's Assemblies of State Parties.
Now, for more on that story, actually, we won't be crossing to Sherwin Bryce-Peace, but we will be looking at the Chief Prosecutor of the International Criminal Court, Fatou Bensouda, who has urged countries that have concerns with the court to raise their unhappiness through existing mechanisms provided for by the court.
She argues that, contrary to common belief that the ICC prefers punitive justice over peace efforts, the court encourages sovereign states to provide justice for human rights abuse victims. She spoke to our Foreign Editor Sophie Mokoena in New York.
Madam, thanks for your time. We meet again here at United Nations.
Indeed.
And I guess you are here, but it has been tough weeks since the announcement by South Africa. How do you feel?
Look, any announcement by any state that's part of the Rome Statute and wants to leave or has withdrawn is regrettable. It's regrettable because I believe that the international criminal justice movement that we all tried to create in 1998 should be supported and also should be maintained and enlarged. This is what we all look for, what we hope for, because I think one of the greatest moments, I said it before, one of the greatest moments of that humanity can be proud of is the creation of the International Criminal Court, and also, putting justice at the center of the this movement, this international criminal justice movement. So I believe any attempt to leave this court or any attempt to not to be part of this movement is definitely a regret.
What was your initial reaction to South Africa's withdrawal and subsequent withdrawal from Burundi and Gambia, your own home country? How did that strike you?
Look, currently, I of course, indeed, I am a Gambian, and the decision by my country and this intention to withdraw from the Rome Statute is something also that is regrettable. But like any other state, I am now an independent prosecutor. Independent, working for the ICC for all countries that are part of the Rome Statute. So whether for my country or any other country to leave the ICC family is something that we deeply regret. As I said before, we need to strengthen the court. We need to support the court. We need to enlarge the court. And attempts to withdraw from the institution is very much regretted.
South Africa believes that the obligations under the Rome Statute are in conflict with some of its obligations internationally. For an example, granting immunity to sitting heads of state and also the AU Constitutive Act. Do you think the reasons are justifiable?
Well, I do not want to comment for the what South Africa, the reason South Africa is giving. What I can say is that this debate of peace and justice being in conflict is a false debate. I think it is time that we also recognize that peace and justice can actually work together. If only we stop to think about the best way in which we can make them work. The Rome Statute itself is an instrument that is a treaty. If you look at it, even envisages issues of peace. For instance, if you look at Article 16. Article 16 is giving power to the UN Security Council where they see that the work of the ICC is going to disrupt, for example, some peace efforts that are being taken place. They can actually ask the ICC to stop in the interest of peace. So it is not that the Rome Statute is completely insensitive to efforts that are being made to achieve peace. At the end of the day, also for ICC to be created, one of the reasons is to also bring about stability, security, and peace to these conflict-torn areas. So this is something that is already envisaged in the statute. My office has also demonstrated sensitiveness to efforts that are being made. We've been very sensitive to efforts of peace. I always like to give the Uganda example, where there was amnesty offered to the Lord's Resistance Army people, and we've always said these are the people that we have already indicted, and we therefore are calling on asking those who are not indicted to come out and take advantage of the amnesty at the time that was being offered by Uganda. So the court is not insensitive to the efforts that are being made to get peace. At the end of the day, also, this is one of the reasons why the ICC was established, to ensure that peace and stability, justice, security returns to the conflict-torn areas.
Do you believe that international justice regime, for example, the countries such as the United States of America, China, Russia, are outside of the ICC, does it present a fair justice around the world?
Look, with respect to these so-called big powers, they always ask me, big powers who are not part of the ICC, I think it's, as I said, whether withdrawing from the court or joining the court is a sovereign decision. And states have different reasons why they want to become part of the ICC or not. And definitely those reasons are not as a result of the existence of the ICC. It's policy decisions that states themselves take. It's a sovereign act. But at the same time, I see that the court has started. The court has been functioning. I see, you will see that over the years, I think the court has come to show its relevance in the international fora, even in the settlement of disputes. The court has become very relevant in all these negotiations. And if you also look at the jurisdiction of the court, the net of the court can be cast much wider than only in the 124 states that are parties to the Rome Statute, because of the fact that ICC has jurisdiction on the territory of a state party, but also over nationals of state parties. So if a non-national were to commit crimes on the territory of a state party, if a non-state party national were to commit crimes on the territory of a state party, ICC could potentially have jurisdiction over that non-national, non-state party national.
America has argued that they have a strong criminal justice system and the judiciary is independent. South Africa also is arguing that they do have a strong criminal justice system and a strong judiciary. Do you think that those reasons are valid?
Look, the ICC is complementary to national jurisdictions. it does not replace national jurisdiction. In fact, one of the reasons for establishing the ICC is to also ensure that domestic jurisdictions take their responsibility. It's a primary responsibility that never goes away, that they take that responsibility to investigate and prosecute on their own. If they are doing it, the ICC will take a back seat. It does not come in. So this complementarity regime was specifically put in there to ensure that the ICC does not interfere where the national jurisdictions are investigating and prosecuting, where we have jurisdiction. So this argument is already taking care of the fact that the ICC is a court that complements and does not replace national jurisdiction. When the domestic jurisdiction is unable or unwilling to investigate and prosecute these serious atrocity crimes, this is when the ICC will step in where we have jurisdiction.
There has been calls that South Africa should work within the state parties to raise the concerns. Mm-hmm. Do you think it would have been better for South Africa to work through the system of state parties to raise their concerns, and perhaps other countries on the continent as well?
Well, maybe it's, I don't want to say what is better or not for South Africa, because as I said, it's a sovereign decision that is taken by a state. But I do believe that having a body such as the Assembly of States Parties, which is the governing body of the ICC, which all the states are members to, all the state parties are members to the Assembly of State Parties, is a forum that these discussions can be made. These discussions can be taken, and the concerns that any state party will have will be raised and addressed. I think before, even for South Africa, in the last Assembly of States Parties, South Africa was listened to, as well as Kenya, for instance, when they have issues that they raise. So this is why this forum was created. As long as they are able to discuss they have the forum, they're able to discuss their issues without, of course, interfering with the independent judicial duties of the court. This is what was envisaged to be done, and I hope that states will take that into consideration and address issues of an institution that they are part of at the forum that was created for that, which is the Assembly of States Parties.
Has the ICC been able to engage South Africa on this recent announcement to try and persuade South Africa to reconsider its position?
This is a matter that I think is really for the Assembly of States Parties themselves, the Assembly itself, that can engage their colleagues, like another state party or a state party that is intending to withdraw. And we had hoped, and we still do hope, that the different states will do that, and also that the president of the Assembly of States Parties will continue his engagement with South Africa.
These kinds of decisions and announcements, how has it impacted on what you are doing, but also to the court itself?
The court was set up to do very important work, which is the investigation and prosecution of crimes against humanity, genocide, and war crimes. And we are doing just that. The work of the court is continuing. I always say that ICC is too important a project to fail. And what is really relevant and important for it.
How do you see the future of the court?
Firstly, talking about the work of the ICC, the work of the ICC continues. It was set up to do a very important work, which is the investigation and prosecution of these very serious atrocity crimes where no one else is doing it. And that work continues. The court is very busy at the moment. both in terms of the trials, but also the preliminary examinations that we are conducting. As we know, we have several, both in and outside of Africa, that we have been conducting for the past couple of years, and that work is continuing. Even with respect to Burundi, for instance, I had announced the opening of a preliminary examination. This is continuing, in spite of the announcement by Burundi that they're withdrawing from the Rome Statute, because this, as you know, from the date of notification of the intention to withdraw, or the withdrawal, it only takes effect 1 year after the notification of the withdrawal. And in this particular case, the preliminary examination that was started in Burundi will continue until the expiration of the 1 year. And if a determination is made, if I make a determination that this is a case that should be investigated, if it starts within that 1 year, it will also, the case will be investigated. So this is just to show you that our work continues. We are involved, as I told you, in very important work, and it is just too important for the court to not to continue with that work. I also want to say that despite this some states parties saying that they're withdrawing, we continue to have very serious commitment from other African states. In fact, many African states are still committed to the ICC, and they have announced this publicly. If you followed the recent debate, you will see that there are several African countries that have expressed their commitment to the ICC and support for the court. And maybe I want to just take this opportunity to express the gratitude of the court to these states for their commitment to continue to work with the court. The future of the court, you will see what I want to see in ICC in a couple of years' time, is that through the work that we are doing, we have been able to demonstrate the credibility of this institution, that we have been able to show the impartiality and the independence of the institution to the extent that states will continue to commit to the court that the victims of these serious crimes who deserve justice will continue to find hope in the court, that the court is there and will bring about accountability and justice for them, and that the court will be respected in all four corners of the world. This is what I see.
And then Libya, how far are you with Libya?
Libya, our investigations are ongoing. You may know that I'm here in New York for the report, the UN Security Council report on Libya, which I do biannually. And I had announced already that our investigations are continuing. I'm asking for more resources to be able to do more, that we're investigating current crimes and also other parties that are part of the conflict. So that work is ongoing. We're engaging with some states who already are also doing some work in Libya and other partners, but it's a work that it's ongoing at the moment.
Do you think the court is doing enough to educate ordinary citizens around the world, particularly on the continent, to understand the reason and the background behind the establishment of the court, but also how will the court benefit the victims?
The court is definitely trying to do that, but we should not be alone in this work. We also need civil society to help bring out the word there about the good work and important work that the court is doing. We also need the media. We need the states themselves to be able to educate the public about the work of the ICC, because unfortunately, one of the challenges that we find is that the court is not known how the court is working is not known. What are the limitations of jurisdiction of the court? And it is very easy for the naysayers to fill this void and start giving a wrong story of what the ICC is all about. It's unfortunate. But as I said, we will do what we can. We will continue to put the word out there of how important this institution is and how this institution was set up. Really, I always say the raison d'etre for creating the ICC is because of the victims who ordinarily will not have justice, because usually those who are supposed to rule them are the ones who are committing the crimes against them, and to find justice at home is very, very difficult. But that there is an institution that they are part of that will independently come in, investigate and prosecute, and that they should have hope in this institution. So this is a story that really should be known out there, because another unfortunate thing is in this whole debate about the ICC and the criticisms against the ICC, the aspect that is missing is about the victims of these crimes. No one talks about them. And these victims, I continue to say, in the cases that we have in Africa, they are also African victims. They deserve justice. In the absence of ICC, who is giving it to them?